I felt, my lord, after arguing on the last occasion, that taking 10-15 minutes of your lordship's time, I must, my lord, advert to those judgments, my lord. My lord, if your lordships have my second note on fundamental rights, my lord, at page PDF 76.
76.
And this is the last submission, my lord. I'll not trouble your lordships anything further. But some judgments, my lord, would really assist your lordships.
The European Convention and its gradual development, that part?
Yes. Lord, may I read 142? In Europe, and the European Court of Human Rights has its seat in so-and-so and is tasked with the compliance by the member states of the European Convention on the Protection of Human Rights and Fundamental Freedoms. The European Court, in the manner, provides an additional forum to litigant to enforce the rights under the ECHR against the against the nation state, which is a member of the convention. The ECHR was entered into force in 1950 and is the main treaty which sets out the civil and political rights and freedoms of European states agree to ensure for people living within their jurisdiction. Lord, Article 8 is similar to Lord, Article 20, almost, not word by word, but peri materia. Everyone has the right to respect for his private and family life, his home, and his correspondence. There is a specific right to marry. Please see this, my lord. Article 12 on PDF page 77. Man and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. Lord, two things. A, even European Convention recognizes a heterosexual marriage and it makes it subject to the national laws of each member state. Yes. Lord, therefore, the ECHR clearly recognizes right to marry under Article 12. Despite the same, European Court of Human Rights has still date refused to locate the claims of same-sex marriage under Article 12. The European Court of Human Rights had consistently denied all claims of same-sex marriages and still does not recognize marriage to be an enforceable right under the Convention. The European Court of Human Rights, after rejecting all claims for about 2 decades, has only recognized limited partnerships to be enforceable, that too in light of larger socio-political consensus in Europe. But this is not majoritarianism. There has to be a consensus on social issues. The said position is clear from a complete reading of the case law emerging from Europe. The European Court of Human Rights, for the first time, examined the issue of whether two persons who are of the same sex could claim to have the right to marry in the case of Schalk and Kopf versus Austria, and found that Article 12, the right to marry, of the convention did not impose an obligation on the respondent state to grant same-sex couples access to marriage. It was held as under, Lord, and I quote, the applicants were born in 62 and 60 respectively. They are a same-sex couple living in Vienna. Lord, kindly skip the Lord, para 50, kindly come to para 58 directly. The court is not persuaded, Lord, it's on page 78, para 58. The court is not persuaded by the applicant's argument, although, as is noted in the Christian Goodwin cited above, Lord, some other previous judgment, the institution of marriage has undergone major social changes since the adoption of the convention. The court notes that there is no European consensus regarding same-sex marriage. At present, no more than 6 out of 47 convention states allow same-sex marriage. Then, my lord, para 60. Turning to the comparison between Article 12 of the convention and Article 9 of the charter, the court has already noted that the latter has deliberately dropped the reference to man and women. So, and so, my lord, I skip the commentary of the charter, which became legally binding, my lord, that's for them, my lord, to para 62, 61 and 62. Regard being had to Article 9 of the charter, therefore, the court would no longer consider that the right to marry enshrined in Article 12 must in all circumstances be limited to marriage between two persons of the opposite sex. Consequently, it cannot be said that Article 12 is inapplicable to the applicant's complaint. However, as matters stand, the question whether or not to allow same sex marriage is left to regulation by the national law of the contracting state. In that connection, the court observes that marriage has deep rooted social and cultural connotations which may differ largely from one society to another. The court reiterates that it must not rush to substitute its own judgment in place of that of the national authorities who are best placed to assess and respond to the needs of the society. In conclusion, the court finds that Article 12 of the Convention does not impose an obligation on the respondent government to grant a same sex couple, such as applicants, access to marriage. Lord, similar is the judgment at page 147. I'll not read it, my lord, but same court, Lord, similar reasoning. Lord, if your lord.
Are you someone who would like to make a career in the IT but struggling to decide that where?
8, my lord, that Oliari judgment which was relied
Yes.
upon, my lord, there the court, my lord, this was not read before your lordship, therefore it's my duty. The court records that in this country there is a larger consensus. Whether your lordships would adopt that, Lord, doctrine or not.
After that, there was a law after that.
Exactly, my lord. Therefore, it
There
was
was a law, but they did not say marriage. They said same, I think it's a civil.
partnership. They said partnership. So, my lord, I am not reading, my lord, but I have collated all judgments on the point, my lord, and placed for your lordship's consideration. Lord, I'm immensely grateful, my lord. Lord, the learned attorney, my lord, would like to assist your lordship.
Yes, Mr. Attorney General.
I shared two notes by mail and also my separate compilations, which before I go into that, give me my copies to everybody. Please give copies to everybody. There's some broad reflections on a matter of such importance and magnitude.
Lord, I was required to convey, my lord, I forgot to convey at the outset. I received a phone from Mr. Sibbal in the morning. Lord, today is little under the weather, my lord, so his absence may kindly be, my lord, dispensed with. His presence may be dispensed with, my lord. Kindly pardon his absence, my lord. I'm obliged.
I must say that I was greatly enriched by the submissions made on the petitioner side. I personally conveyed my appreciation of some of the deep insights which I received on a subject like this. And it will be, well, at one level, the court is engaged in a nobler task, we put it like that. For a different level, it is a matter where mere court engagement or engagement of counsel, howsoever enlightened we are on the subject and howsoever deeply committed to it, objective, neutral, and all that notwithstanding, the subject calls for a, if I put it like that, one, if you want looking at practical outcomes, an incremental approach. And if you have to go deep into certain fundamental constitutional questions, then ultimately one will find that you will not be able to answer them. So yes, this is the final answer. So that's where cases like this stand. I would probably continue with some line of reasoning with the learned solicitor who was placed before your lordships. And well, you look at the larger picture about how does the court take a stand on matters like this? On the one hand, we will have references from various constitutional court decisions from across the globe on certain principles of interpretation, which may seem to be on the evolving side of promoting human rights and fundamental rights and so on and so forth. Guidance has been repeatedly sought about. But if you look at the global scene, even looking at the Commonwealth, perspectives, you'll also find wide-ranging difference between the New Zealand approach and the English approach. With the New Zealand Bill of Rights and notwithstanding similarity between Section 3 of the Human Rights Act and Section 6 of the New Zealand Bill of Rights. So it's not that that we have a certain universal perspective on certain aspects of the matter on which there is no disagreement at all. Before I read my written note, I thought I'd like to lay some broad canvas of what I'm not to be taken that the court has no business at all to be engaging in this matter, in the sense, in a fundamental sense, because when matters of nature brought to the court, it's certainly the duty of the court to engage itself on unraveling the constitutional dimensions of any and to find out within the scope of constitutional deliberations a possible solution can emerge without the court fundamentally altering the texture of the Constitution or the text of a statute, so on and so forth. So that's a basic line which the court would probably not keep it in mind and probably not breach, except for saying that, yes, this is a matter on which, because we follow a certain set of precedents like Vishaka, we look at how you fill in vacuum, etc. So all that will be essentially materials and resource for the court to take a holistic view of the matter. So if the court were to ultimately say, take suggestions well today morning regarding whether the government cannot respond to a certain set of suggestions, which may probably address some immediate concerns, so one can certainly look at them. But what the executive can do within the possible legislative frameworks available today or going out of the existing legislative frameworks, and what the parliament can do, the lines must be very clearly drawn. So if the lines are not drawn, then perhaps there are other interminable consequences which will follow. So all that I say does not mean that the court will not probably deliberate on the subject. But at the end of the day, where the lines will be drawn is a very important question to be asked. So having said that, let me take your losses through two of my written notes. Before I also do that, just to on a little abstract level.
There's one actually.
Leonard, it's only one written submission that
I have two written submissions which have been mailed to your lordships. I hope your lordships have that.
That's right.
We have the
There's
written submission. We have the written submissions.
Revolutionary.
We have the written submissions. Okay. Yes, yes. There's an additional written note. Yes. Are we looking at the first one or the additional one right now?
I would have loved to take your lordships to some of the recent reflections by jurists across the globe, particularly, for instance, Habermas and Alexis in his very recent book on idealism and the law talks about how Dworkin's perspectives and Habermas' reflections have a certain difficulties in drawing final conclusions, like what Professor Lawrence Tribe talks about, the invisible constitution, and what we read in the soundings and silence. I'll probably take your lordships into some of them a little later, because they give us a broad perspectives on, while we have different constitutional frameworks and emerging from those constitutional frameworks, for instance, the 8th Amendment, the 9th Amendment, and all those the 10 amendments in the US Constitution, the Privileges and Immunities Clause in the US Constitution, the due process emergence, all that, as Professor Mark Tushnet says, the US Constitution is old, not easy to amend, and therefore somewhere somebody must have the job of interpreting the Constitution. I'll take a lot through all that. Let me first read my first written submission. May read that?
Yes.
In the light of the summary of submissions made on behalf of various petitioners, it emerges the Honorable Court has called upon to declare that persons with non-heterosexual orientations and non-heterosexual classes of persons have a right not to be discriminated on the ground of sex and as regards the availability